Hi, it's Wendy Hernandez, attorney and creator of Command the Courtroom. If you and your ex have already received a court order where the court has dictated what sort of custody plan you're sharing with the other parent and what parenting time looks like and what child support looks like, hopefully things will be settled for a while. In many of my cases, though, even after a court has issued an order, parties still end up getting into arguments and falling into dispute. And a lot of these people who are in the middle of disputes with their exes, they come to me and their immediate knee-jerk reaction is wanting to file a lawsuit. So if you've ever been to family court before, you know already that filing a lawsuit is not the path of least resistance. In most cases, it takes a lot of energy, it takes time, it takes money, it takes patience, and it can be overwhelming. So when people come to me and they tell me, my ex and I aren't getting along because of X, Y, and Z, I almost always ask them, is there a way that we might try to work this out with your ex before returning to court, before my filing a lawsuit? And in fact, in a lot of cases, I look to the original orders that the court entered because there are provisions in there saying that the parties have to go to mediation or have to go to some sort of alternative dispute resolution prior to filing a lawsuit. And by all means, if that provision is included in the court's original order, then I tell my client they have to do that. There are a handful of cases nowadays, though, where there's not a provision requiring mediation prior to filing a lawsuit. And it's almost always my advice to my client or the potential client that we should see if we can work it out first, because that is the path of least resistance. And there are cases where parties are able to reach agreements without having to file a lawsuit again. And what it looks like is if you approach the other person, and you could do it in person, you could do it via an email, if that's how you communicate, you can do it via text. If you decide to hire an attorney, then you could have your attorney write a letter to that person or their attorney and say, these are the issues that we're experiencing, this is my proposed solution, can we talk about it? And if you're able to work it out, then what ends up happening is you file a agreement or a stipulation with the judge saying, we've decided to make changes to your original order. We agree on those changes, and these are what the changes are. And in most cases, as long as those changes are in the best interest of your child and they're fair, the judge will sign off on them. No court required. Minimal attorney's fees required. So instead of going straight to the mat and boxing it out with the other party, think about whether there's a possibility of working it out. And I know that you're thinking, oh, there's no way we can work it out. But I've been shocked in some cases, and it doesn't hurt to try. You could save yourself a lot of time and heartache, potentially, by just trying. On the other hand, if you just file a lawsuit, you know that you're in for a roller coaster ride during the time that that lawsuit is going on. So I hope that helped. Remember to like this video if you did like it. Subscribe to my channel on YouTube, Command the Courtroom. Go to Command the Courtroom on Facebook. Check out commandthecourtroom.com. Keep on trucking, and until next week, remember to command the courtroom.